My Lords, we're looking at the judgment of the Court of Justice in Carte Bancaire, Authorities Bundle 1, Tab 6. If I could ask your Lordships first to turn to page 397 in the bundle. And you'll see at page 397, this section of the Court's judgment that I'm going to refer you to is the heading above paragraph 65, the first plea, which refers to the infringement of Article 181, now 101. And that ground, the first ground of challenge, is broken down into three, what the Court calls pleas. If you could let, and I want you to turn to the next page, paragraph 71. And you'll see the three parts of that first ground. If I could ask you just to look at paragraph 71 to set the scene. And the Court of Justice considers the second part before it considers the others, and you'll see there's a slightly unclear, but it's a heading between paragraph 71 and 72 regarding the second part, drawn from the non-consideration of the independence of the issuing and acquiring activities. And could I ask you to read, just to set the scene, paragraph 72 down to 73. And those are the arguments summarised in paragraphs 72 and 73. And then the Court comments in paragraph 74. And you'll see that's relied upon, that paragraph is relied upon by the schemes. So I'll look at it. It says, it should be recalled that according to the case law, the assessment of the effects of coordination between undertakings with respect to what's now Article 101 involves the need to consider the actual context in which the coordination arrangement in question is situated, in particular the economic and legal context in which the undertakings concerned operate, the nature of the goods or services affected, as well as the real conditions of the structure and functioning of the markets in question. And the Court refers back to its previous judgment in the MasterCard judgment, point 165.
Yeah.
So that's a pretty standard and uncontroversial statement of the assessment that needs to take place. And then if you look at paragraphs 75 to 76, those in turn refer to paragraphs 177 and 179 of the Court of Justice's judgment in MasterCard. And again, I ask you just to read those to yourselves.
Yeah.
And so, my Lords, what I say you can take from those paragraphs is the following. In our submission, these paragraphs make it clear that the counterfactual, for the purposes of a primary Article 101(1) assessment of anti-competitive effects, needs to consider the actual factual and legal context of the markets in question. And that actual factual and legal context of the markets in question includes a two-sided nature of markets in a payment scheme setup. Now that, my Lord, that proposition is uncontroversial and agreed by my clients. And I have explained how one needs to take into account the economic context in the present case. If you go over, my Lords, to page 400, paragraph 82, that's also relied upon by the schemes. And if I could ask you to read that to yourselves. And the proposition there set out that, and I quote, within the framework of a two-sided system, one of the parts of this system could constitute the market relevant for analysing the anti-competitive effects, in this case the issuing market, and that the other part of the system can be considered as a separate related market, in this case the acquiring market. The existence of interactions between the relevant market and a separate related market is a contextual element to be taken into account in the analysis of the anti-competitive effects on the relevant market, namely in this case that of issuing. Again, that is uncontroversial. In my submission, just to note that in this case, in the carte bancaire case, the restriction of competition was said to occur on the issuing market, whereas in our cases it's on the acquiring market. But it is uncontroversial in my submission that the restriction of competition can take place on one market, but it is also relevant to consider in assessment of effects the fact that there are other separate related markets. And as I said, that's uncontroversial. In my submission, in our interchange cases, the Supreme Court and the Court of Appeal clearly held that the market relevant for analysing the anti-competitive effects, as it's put in this paragraph 82, in the MasterCard cases, the Supreme Court and the Court of Appeal clearly held that market is the acquiring market, on which acquirers offer services to merchants. So that is the market which is relevant for the purposes of assessing anti-competitive effects, purposes of establishing whether there's a restriction. However, it is relevant in considering the restriction on that particular market to consider that there are separate related markets and the economic incentives and dynamics that result from that. And I have explained how in our case, dynamics in the related markets, the issuing market and the market on which payment schemes compete between themselves for transaction volume. And I have explained why, in our case, issuers, acquirers and the schemes all have a common commercial interest and incentive to impose interchange fees. And I have made my submissions as to why in our markets that led to the necessity of the settlement at par rule. If you then turn to page 403 in the carte bancaire judgment, that finishes the relevant paragraphs for the second part of the first ground of challenge. On page 4, which just sets out the general approach, page 403, at the very top of that page, there's a heading between paragraphs 101 and 102, which is the first part of the first ground of appeal. And that's drawn from the non-consideration of the competitive situation in the absence of the markets in question. So that's...
Measures in question.
Sorry, measures in question. So that is a criticism by the schemes in this case, carte bancaire, about the Commission's failure to properly define a counterfactual in the absence of the measures in question. And it is here, my Lord, where I make the submission that the Court of Justice makes it clear that in looking at this question, what would the competitive situation in the absence of the measures in question be, one needs to be very careful not to elide the issues of establishing a counterfactual for the purposes of the effects analysis, with the separate question of whether there's an ancillary restraint or objective necessity, with the yet further question of exemption under Article 101(3). So if you look at paragraph 102, the applicant blames the Commission for refraining in the contested decision from analysing the competitive situation in the absence of measures in question, that is, analysing the counterfactual, under two essential aspects. The criticisms are that in analysing the counterfactual, the Commission did not take into account the risk of parasitism suffered by the carte bancaire system, number one, or the competitive situation on the payment systems market in the absence of these measures. Note that the competitive system on the payment systems market is a different market, a separate related market to that on which the measures are said to have anti-competitive effects. The market on which the measures are said to have anti-competitive effects in carte bancaire is the issuing market. The criticism is made about the Commission's failure to take into account the competitive situation on the payment systems market, a different related market in the absence of the measures. If you look at paragraph 104, criticism is specifically made as follows. The applicant claims the Commission did not respond to its argument raised during the administrative proceeding, according to which, in the absence of the measures in question, the carte bancaire system was likely to permanently weaken on this related market, the payment system market, and according to which its very survival was under threat. According to the applicant, the Commission should have examined the competitive situation in the absence of the measures in question on the only market where the group was present, namely the payment systems market. Now, in paragraph 105, the court responds to this argument. As a preliminary remark, it should be noted that by blaming the Commission for not taking into account in its analysis under what's now 1011, the fact that the measures in question were necessary in fighting against parasitism of the carte bancaire system and in fighting against the risk of weakening the carte bancaire system on the payment systems market, the applicant seems to maintain the Commission should have examined the effect of the measures in question with regard to the theory of ancillary restraints. So the court is there saying the applicant seems to be confusing the issues of the correct counterfactual for the purposes of an effects analysis with the argument on ancillary restraints. And it appears that this point was raised in the court hearing because it then says in paragraph 106, however, during the hearing, the applicant firstly indicated that by this line of argument it was not invoking the theory of ancillary restrictions, and secondly admitted this theory was not applicable to this case. And then the court goes on to say, so, paragraph 107, could the risk of weakening the system be, assuming we're not dealing here with ancillary restraints, could the risk of weakening the system, and I'm now here summarising and we'll go through the wording of this paragraph, but in paragraph 107 the court is putting to itself the question of could the risk of weakening the system be taken into account as part of the context for setting a counterfactual. So they've said, it's clear they're not pursuing an ancillary restraints argument. So should we consider the risk of weakening the system as part of the context for the counterfactual? And the court goes on to hold in paragraphs 108 and 109 that one should not. So I'll take you through those paragraphs with that introduction. Paragraph 107. Given that the theory of ancillary restrictions was not invoked by the applicant, it should be considered that it argues, the applicant argues, that the risk of parasitism on this carte bancaire system and the risk of weakening this system on the payment systems market must be taken into account as contextual factors which the Commission had to assess the competitive situation in the absence of the measures in question. Indeed, according to the applicant, if the Commission had taken into account these risks in its analysis of the competitive situation in the absence of measures in question, it would have had to note the absence of restrictive effects of these measures under 1011. Now, I only have to read that out to effect, I hope, make it clear to your lordships that the arguments that were being made by the applicant here in the carte bancaire case are effectively the arguments that are now being made against us by MasterCard and Visa.
I don't quite follow that.
They are
because
saying that
they're saying, well, the risk, you ought to have taken into account the risk that the system might collapse.
yes,
Whereas what's an issue here is whether they can say, look, if we hadn't had an anti-competitive measure, this is actually what would have happened. They're not talking about risk of collapse. And you then want to say, well, no, that proposed counterfactual isn't a legitimate one. It doesn't seem to have anything to do with these paragraphs.
well, my lord, perhaps it's just the flip side of the case here. They're saying that, or the applicants in carte bancaire are saying that essentially hold-up arguments, the risks of the hold-up arguments are prayed in aid by MasterCard and Visa because they say the situation of hold-up is such that if we don't have a rule in place, the whole thing will collapse. Here, they say in carte bancaire, they're saying that a similar argument is being made about the risk of weakening the system on the payment systems market if we don't have the measures in question. And the applicant's saying that there are those risks in the absence of the measures in question. You have to note the absence of the restrictive effects. So they're saying if the Commission had taken into account these risks in its analysis of the competitive situation in the absence of the measures, it would have had to note the absence of restrictive effects. So they're basically saying the hold-up arguments mean there are no restrictive effects. It's a flip side, but it's a similar argument to this. We need the counterfactual because to show that there are no competitive effects. And the points are made at paragraph 109 and 108 and 109, and it is these important points. According to established case law, to determine whether an agreement must be deemed to be prohibited due to resulting distortions of the competitive process due to effects, it's necessary to examine the process of competition in the actual context in which it would occur in the absence of the disputed agreement. This method of analysis, particularly with regard to the consideration of the competitive situation that would exist in the absence of agreement, does not amount to carrying out a review of the pro and anti-competitive effects of the agreement, and to be applying in this way a rule of reason. The examination required under 1011 consists essentially in considering the impact of the agreement on the current and potential competition and the competitive situation in the absence of the agreement, these two aspects being inextricably linked. So we're not saying that when you look at the counterfactual, the absence of the measures in question, you carry out a balancing of the pro and anti-competitive effects. That's a rule of reason which we don't have in European law. What you look at is the absence of the restriction. Then if I can ask you to turn to the top of page 405, paragraph 118. This is the second argument, which is again considered by the court. The applicant's argument that the Commission should have examined the competitive situation in the absence of the measures in question on the only market in which the group is itself present, that is the payment systems market, and thus take into account the risk of weakening the carte bancaire system on this market in the absence of the measures in question. It should be noted that by this line of argument, the applicant does not blame the Commission for having carried out an erroneous analysis of the competitive situation on the issuing market in the absence of the measure in question by not taking into account the context ensuing from the situation on another market. It blames the Commission, in fact, for not having analysed the competitive situation in the absence of the measures in question on another market other than the relevant market on the payment systems market. So although it's rather tortuous, what appears to have been happening here is that carte bancaire says, without these measures, the fees that we're imposing in the issuing market, without those measures, the impact on the payment systems market, the separate market, would be such that the carte bancaire system would be weakened. And you have to take into account the weakening of the carte bancaire system in the counterfactual. In order to carry out a proper counterfactual analysis, you have to effectively say that without these measures, we need these measures because they're going to affect competition they're going to weaken the system on the payment systems market. And you need to consider that alongside your assessment of the counterfactual on the issuing market, which is the relevant market for the purposes of the competition analysis. And in paragraph 121, the court says, if by that line of argument the applicant intended to evoke the situation on the related market, the payment systems market, as a contextual factor in assessing the play of competition in the absence of measures in question on the issuing market, it should be noted it does not explain how taking into account the competitive system on the situation of the system on the payment systems market would be likely to call into question the Commission's analysis of the competitive situation on the issuing market in the absence of those measures. It says they're totally different markets. And the point is made in paragraph 124, by claiming the Commission should have taken account of the fact that in the absence of the measures in question, the competitive situation of the carte bancaire system on the payment systems market, the separate market, risked being weakened. The applicant argues in substance you should have taken into account the fact that the measures aimed at strengthening the competitive position of the CB system in relation to its competitors on the payment systems market. It should be considered that the applicant blames the Commission for not having proceeded to a review of the pro and anti-competitive effects of the measures in question during its analysis of the situation under Article 81(1). And then over the page, however, it should be recalled, according to the case law cited in point 109 above, that would have amounted to a carrying out of a review of the pro and anti-competitive effects of the agreement. And as we've seen in 109, that that is not what needs to be done for the purposes of the counterfactual analysis. The question of knowing whether the restrictive effects of the measures on the issuing market would be counterbalanced by the alleged restrictive effects on competition in the payment systems market that would occur in their absence stems from the analysis under 101(3). In this regard, the Commission deemed that the Group's argument relating to the indispensability of the measures for the survival of the carte bancaire system would be examined within the context of 101(3). So, the court is there making the point that whether the restrictive effects of the measures in that case on the relevant market, the issuing market, here the acquiring market, are counterbalanced by restrictive effects on competition in the payment systems market, that is the weakening and the collapse of the scheme, those points are only relevant to the balancing exercise carried out under 101(3). And the point is made again in paragraph 127. Furthermore, it should be noted, and then they refer to a previous decision which is not the same provision as the VISA decision. The Commission had considered that VISA's argument that in the absence of the MIF, the extent of VISA's activities and therefore their competitive impact would be greatly reduced, would be examined with regard to 101(3) and not 101(1), for which the question arose was to determine whether the clause was technically necessary for the functioning of the payment system. That's the ancillary restraint argument. According to the foregoing, the applicant is wrong to blame the Commission for a methodological error in its analysis of the competitive situation in the absence of the measures in question. So, according to the foregoing, the applicant is wrong to blame the Commission for approaching the question of counterfactuals incorrectly. These issues, insofar as they are relevant, what happens if the measures are not there on the related markets, and the argument that without these measures the scheme would be weakened or would collapse, are relevant only to either an ancillary restraints argument, which we hear is not being pursued, or the balancing under 101(3). So stepping back, and I'm afraid it was rather a canter through that judgment, which is quite dense, but stepping back, what do I take from that judgment? The first point that I take from that judgment is that insofar as there is anything in the scheme's arguments that the anti-competitive effects on the acquiring market, which may result from a default MIF rule, or from VISA's unilateral interchange fee mechanism, or from MasterCard's bilaterals arrangement, insofar as there's anything in their argument that the anti-competitive effects on the acquiring market which result from those arrangements are outweighed by benefits which arise from such rules because they ensure the survival of the scheme, those arguments only go to the Article 101(3) analysis. They are not relevant to the prior question of the correct counterfactual analysis for the purposes of 101(1).
It wasn't argued here, as I understand it, or it's not being argued here.
Well,
Is it that the scheme would collapse were it not for the MIF?
the argument is the scheme would collapse were it was argued the scheme would collapse were it not for the MIF. Now it's being argued the scheme would collapse. Now it's being argued.
One of the cases, I forget which one, that was argued.
Yes.
But by the time we got to the Court of Appeal, my recollection is they didn't argue that.
No, my lord, but they are arguing that their post-IFR counterfactual, the UIFM and the MasterCard bilaterals arrangements are necessary because otherwise interchange fee levels would be unconstrained and the schemes would collapse.
I have to say, I mean, I may have misunderstood. That isn't how I understand the argument.
Right.
The argument, as I understood it, was they say, well, look, if we take away the objectionable measure, this is actually what would have happened.
Right.
And then it seems to be for you to say what they say would have happened, either would not have happened, or could not be allowed to be taken into account because it is itself objectionable. And that seems to be the other way round.
If that is it, then that is fine.
My lord, I can confirm that that is it. And can I do hesitate to rise, but before, I don't know whether my learned friends are moving off this judgment. there's one paragraph in this judgment which I think my learned friends skipped over to avoid me coming back to it. I wonder if I can invite my learned friend to show your lordships paragraph 111,
Yes, of course.
page 404. Is that in fact the only, I think, paragraph that we rely on?
My lord,
And
yes.
simply for the sake of it being on the transcript, MasterCard's position is also aligned with the question asked by your lordship.
Page 111, take you back to 111, it's on page 404. Sorry, you're right, it's,
111 to ourselves.
thank you. So, the second point I take, and again, this is probably unnecessary because it's also been confirmed that this is not an objective necessity or a necessary restraint case, no such arguments are being made by the schemes. But insofar, such analysis, it's clear from this judgment, can only be carried out on the same market as on that on which one finds the restrictive effects in competition. Carte bancaire.
Because carte bancaire was cited to the Court of Appeal in
Yes.
Visa and MasterCard, and I can't now remember, I couldn't
Paragraph
find.
111.
Yes, well, my lord, I'm about to,
Is that point?
if Mr.
It's the
Rabinovitz
paragraph
can,
111
if Mr. Rabinovitz can
paragraph.
control himself, I am about to
I'm
take
trying to answer a
my
question.
lord to the, I know, it's very exciting, but,
It is, it's very exciting. It's paragraph 111, which is cited by the court.
yes, my lord, and I'm going to take you, if I may, to the Court of Appeal's judgment.
Yeah, thank you.
In that regard, because I make the submission that as regards ancillary restraints, the Court of Appeal and the Supreme Court in MasterCard has already made clear findings on ancillary restraints in the context of interchange fees. So if your lordships can put away Authorities Bundle 1 and take out...
It's a rather literal translation from the French, isn't it? I say it's an official translation, but it's not of the best, that's for
No, dense is perhaps a little kind. So, my lord, if I could ask your lordships to get out Authorities Bundle 3. Tab 12 is the Court of Appeal judgment. And if I could ask you to turn to pages 1047. Page 1047. If I could ask to yourself, read to yourselves paragraph 188. This is the death spiral argument, which is how the ancillary restraint argument was made in front of the Court of Appeal. And the point is there made by the Court of Appeal, the finding, the Article 101 question is to be asked in relation to the acquiring market. And my Lord Justice Flo, I think, had that in mind. And if
Well,
you then,
the actual
126.
that death spiral argument has been dealt with earlier in the judgment. from
Yes.
recollection.
yes, my lord.
The reference to carte bancaire, if that's what you're looking for, is a paragraph 126.
126,
page 103.
thank you very much. I know I'd seen it at some point when I was rereading it the other day.
Yes, my lord, perhaps we could go back to that as it's on a slightly different point. It's a point I think I've already addressed. In 126, the Court of Appeal cites, correct, yes, Mr. Rabinovitz, correct, paragraph 111 of carte bancaire, and makes the point that then applies it in the way that I have urged your lordships that it needs to be applied. The scheme's arguments as to the correct counterfactual ignore these fundamental propositions. The measures in question in this case are the agreements between the issuers and the acquirers to be bound by the scheme rules set by the scheme defendants, or put even more simply, the scheme rules set by the scheme defendants. Those rules set default MIFs payable in the absence of bilateral agreements being reached. Without those measures, there would have been no interchange fees charged unless bilateral interchange fees were agreed between issuers and acquirers, which was common ground, save in relation to Cat's decision, to which we will come in due course. It is true, and I would ask you to carry on reading in 128, it is true, as Miss Rose argued, that there has to be a rule as to settlement, but it is not true that such a rule has to include a MIF, negative or positive. The magic of zero is that the measures in question namely the agreements to impose default interchange fees, and I would pause there. The agreements to impose default interchange fees, not a particular level of fees, but the agreement to impose the fees themselves. The magic of zero is that that agreement, those agreements are absent, and then I would ask you to double underline the following cases. It is therefore necessary to ask whether in a world without the scheme rules that set a MIF in default of bilateral interchange fees being agreed, there would or would not be more competition in the acquiring market. And it is there, the Court of Appeal is considering Article 1011. And the Court of Appeal is considering it in the context of paragraph 128, in which Ms. Rose, then counsel for VISA, argued there has to be a rule as to settlement. So it's not just the absence of the default MIF settlement rule, but it is its absence to, and there has to be a rule as to settlement. But that rule must not include a MIF. The agreements to impose default interchange fees are absent. And we say when one reads the Court of Appeal's judgment and then one reads the Supreme Court's judgment as to what the counterfactual has to be, it is in our submission clear that it's not just getting rid of the default MIF rule or getting rid of agreements to impose default interchange fees altogether. It's also there has to be a rule about settlement. And you will see that that's explicit, and I don't need to take you back to them, but that's explicit in the Supreme Court judgment as to it's no default MIF plus settlement at par. It's those two aspects. And that is what the Court of Appeal finds on the back of paragraph 111 of carte bancaire, as one would, because you need to consider the market in its context. And I've described that, and I'm not going to repeat myself.
Yeah.
So if I can then turn, sorry, and just to finish the point insofar as any ancillary restraint argument is made, paragraphs 198 to 200, the Court of Appeal makes it absolutely clear that it was, there's evidence, and the schemes did not dispute that evidence, that a scheme without a default MIF settlement rule and settlement at par could operate. Such schemes are operated in other countries and they will not collapse as a result. Might be just worthwhile looking
Are
at
we
that.
concerned with an ancillary restraint argument in this appeal?
No, my lord, but it's just another example of the counterfactual, what the counterfactual is. The counterfactual is no default MIF plus settlement at par. And they look at that counterfactual and they say that's the counterfactual we apply for the purposes of 1011, also the counterfactual we apply for the purposes of the ancillary restraint argument, and we conclude, when we're applying it for the second purpose, that such schemes could survive. So it all just goes to support my argument that that is the counterfactual that the Court of Appeal were applying. It's two-pronged counterfactual, in other words, and that's what it did on the back of the carte bancaire case and the MasterCard Court of Justice case. It's applied in two contexts. It's applied in the effects analysis context, it's applied in the ancillary restraint context. But it will be suggested to you that all you need to do to get a proper counterfactual is take away the default MIF settlement rule and have no regard to the requirement for settlement at par. That's what will be suggested to you. And they say, therefore, our counterfactuals are proper counterfactuals. And we say, no, they're not. And that was not the counterfactual that the Court of Appeal was looking at. That's not the counterfactual the Court of Appeal had to said applied as a matter of law, applying the test in carte bancaire. It's not the counterfactual the Supreme Court applied for good reason. Because competition could not occur, as we can see from what the schemes say will happen under their proposed counterfactuals. Competition could not occur without those two prongs, getting rid of the default MIF rule and having settlement at par. Well, that's just borne out by what they say will occur if we don't have a settlement at par rule. They say we'll find another way of imposing interchange fees and they'll be imposed at exactly the same level. So, my lord, if I can then turn to ground 1B, and this is a more limited point. And the point is this: whether the tribunal was correct in law, we say it was not, to hold that Visa's unilateral interchange fee mechanism counterfactual and MasterCard's bilateral arrangements were not or did not fall within the definition or the concept of, quote, agreements or concerted practices for the purposes of Article 1011, because they did not involve collective arrangements. They were purely unilateral. And you'll appreciate the difference between 1011 being concerned with agreements and concerted practices, this strange European concept, agreements and concerted practice on one hand, and Article 102 being concerned with anti-competitive unilateral conduct by a dominant undertaking. So there's a difference between unilateral conduct and agreements or concerted practices. But the definition of agreements and concerted practices, the concept of agreements and concerted practices for the purposes of European competition law is extremely broad. They are not contracts, they do not have to be written, they do not have to be oral, they are simply arrangements between competitors. I'll come to that. So, my lord, we say there was a clear error on the part of the tribunal, and moreover, the tribunal's approach to this question was inconsistent with the other sections in its judgment, where it set out the correct test for finding an agreement or a concerted practice for the purposes of Article 101. But then, in its finding on the scheme's post-IFR counterfactuals case, it failed to apply that test to the facts before it. So if I can take you to the CAT judgment, which is in the core, you can put away authorities 3 for the moment, although I am going to be reopening it. But if you turn to the CAT's judgment in this regard in the core bundle, tab 5, please turn to page 177. And you'll see from 176, the heading halfway down that page, G, the heading is the acquisition of VISA Europe Ltd by VISA Inc. You'll see that the tribunal was considering here the arguments that did not succeed in front of the tribunal, but are being brought appeal by way of cross appeal by VISA about the impact of interchange fees being set by VISA Inc. and VISA Europe being acquired by VISA Inc. But it is in this context that the tribunal sets out the European law or the relevant law on what is an agreement or concerted practice. And if you look at paragraph 94, and we say they here correctly set out what is the law on what is an agreement or a concerted practice. If I could ask you to read paragraph 94. So I'd also ask you to read the findings of fact that the tribunal made in paragraph 95. The visa scheme rules and MIFs imposed thereunder are binding under the agreement between each issuer or acquirer with Visa. It is fundamental to the operation of the visa scheme that every issuer and acquirer knows that every other issuer and acquirer in the scheme is bound by the same rules. And then if I could ask you to turn over the page and look at the tribunal's judgment of paragraph 100, where the tribunal considers various arguments made by Mr. Rabinovich, which we'll come back to in the context of the cross appeal. But for these purposes, if I could ask you to look towards the bottom of the page, there is a sentence starting, moreover, it is fundamental that. If your lordships have that. And it's moreover, and again I say, that the tribunal here correctly sets out what the definition of an agreement is for the purpose of Article 1011. It is fundamental that agreement for the purpose of Article 1011 does not require a legally binding agreement. A mutual understanding that inhibits a freedom to determine conduct independently will suffice. Concerted practice, as explained above, is a still looser concept, but reflects the same approach. So, these are, as I've said, loose concepts. They are mutual understandings inhibiting parties' freedom to determine their conduct independently. That is what agreements or concerted practices, and there is no bright line between the concept of an agreement and the concept of a concerted practice. They are a continuum. That is what they are for the purposes of Article 1011. And here the tribunal says a concerted practice is a still looser concept. As, and if just to finish this point, if I could ask you to look at Authorities Bundle 3, same, Authorities Bundle 3, tab 10, where Your Lordship Lord Justice Newey's judgment in Balmoral Tanks is contained, and in paragraphs 16 and 17 on page 964, Your Lordship's judgment refers to the concept of concerted practices, refers to the judgment in ICI, which describes concerted practices as a form of coordination between undertakings which, without going so far as to an amount to an agreement properly so called, knowingly substitutes a practical cooperation between them, the undertakings, for the risks of competition. If I could ask you also to read paragraph 17, which is a quotation from all of these leading cases of Suka Union. So I think it's trite, and it is, I would assume, common ground, that a concerted practice, the concept of agreement is pretty broad. It's basically collusive collective arrangements. A concerted practice is even broader. It's a form of coordination between undertakings which knowingly substitutes practical cooperation between them for the risks of competition. So it's that concept, that test, that needs to be applied when I use, for example, the shorthand of arrangements. When I talk about arrangements, that is what I'm talking about. An agreement or concerted practice for the purposes of 1011, which is this very broad concept.
However broad it is, there is, it appears from the Suki Uni judgment, a distinction between that and independent operators
Yes.
all coming to the same decision because they think it's in their own interests.
My Lord, yes. And I'll address that, if I may, in the context of the two different counterfactuals. That is the line. It's a grey scale, and there is a point at which a line is to be drawn, but that's the line. It's also important as to understand why these concepts are defined as they are. Why agreements and concerted practices are defined in the way they are as a matter of European competition law. And in that respect, can I ask you to look at the Court of Justice's judgment in MasterCard, which is in, I put away wherever we were, Authorities Bundle 3, I think, and turn to Authorities Bundle 1. The Court of Justice in MasterCard, paragraph 63, which is on page 354. Sorry, tab 5. Authorities Bundle 1, tab 5, page 354. Page 354, at the top of that page, paragraph 63. Thus, it is settled case law that although Article 81, now Article 101, distinguishes between concerted practice, agreements between undertakings, and, which is not relevant for the purpose of this case, decisions by associations of undertakings, the aim is to have the prohibitions of that article catch different forms of coordination between undertakings of their conduct on the market. And then I stress the last 3 lines, and thus to prevent undertakings from being able to evade the rules on competition on account simply of the form in which they coordinate that conduct. So that is the purpose, the aim of this broad definition of these contacts, sets. So applying those tests against that aim to the Visas and MasterCard's proposed post-IFR counterfactuals. And I'll look at each of them in turn, if I may. First of all, Visa's unilateral interchange fee mechanism. I've shown you Visa's description of that unilateral interchange fee mechanism, but it might assist for the purposes of this part of my submissions just to go back to Supplementary Bundle 1, Tab 6. Mr. Livingston's witness statement, paragraph 9 on page 193. I've already taken you to that, but it's relevant in this context. And so what their proposal, this is Visa's proposal, proposed counterfactual, what they say would happen is there would be an amendment to Visa's rules. So there would be a new rule in effect to provide.
Which paragraph were you looking at?
I'm sorry, paragraph 9. I've already taken your lordships to that paragraph, but I'm now returning to it in this context, the concept of whether this is an concerted practice. An amendment to Visa's rules, so a change to the rules, to provide that in the absence of bilateral agreements between issuers and acquirers, domestic consumer and intra-EEA transactions must settle at par unless, and this is the important point, unless the relevant issuer had previously specified it was only willing to settle on the basis of an interchange fee chosen by them unilaterally. Under this model, Visa's rules would also have required, so there's also a requirement in the rules, for the issuer to notify Visa of the interchange fees it intends to apply and to publish those fees. So the amendment, in summary, to Visa's rules is to provide that in the absence of bilateral agreements, the issuer can choose whether or not to impose an interchange fee, and if it chooses to do so, it's required to notify Visa of that fact, of the level of the fee, and to publish that information. If it chooses not to do so, the domestic and intra-EEA transactions are settled at par. Now, we also know from Mr. Livingston's witness statement, and I showed you paragraph 13, that Visa's evidence is that it is very likely issuers would have independently chosen to specify the maximum interchange fee because this would have maximised their revenue. So interchange fees paid by acquirers would have been materially the same as the MIFs set by Visa since the 9th of December 2015. So they say, we will provide in the rules that you can do this, issuers, you can set interchange fees. That's what we provide in the rules. You can set interchange fees. We know that they will do that they will take that opportunity, which is provided in the rules, and they will set interchange fees. In the highly unlikely event they don't, then they have to settle at par. But Visa's case is that they will set interchange fees at the same level as the ones they are setting under the default MIF rule. So that is provided for in the rules. The scheme rules have clearly been held by the Court of Appeal, the Supreme Court, by the Tribunal, to be an arrangement, an agreement or concerted practice for the purposes of Article 101.1. And the fact that there is now a slightly different scheme rule collectively agreed between issuers, acquirers and the scheme, which provides something slightly different, but provides if you want to impose an interchange fee, you can, but you've got to tell us what it is and you've got to publish it, and it has the effect of ensuring that they all do, we say that is clearly a collective arrangement for the purposes of an agreement or concepts of an agreement or concerted practice for this, for Article 1011. The alternative is that there is unilateral conduct on the part of an issuer. There is clearly not. There is action taken by an issuer pursuant to collectively agreed scheme rules, which provide that the issuer is to apply an interchange fee unless it chooses to apply settlement at par. That is an agreement, a collective arrangement. The question then is whether it has an anti-competitive effect. But it certainly is a collective arrangement. Then the question you look to is whether it has an anti-competitive effect. And we say by doing that you compare it against the correct counterfactual. But the prior question of whether there's been a collective arrangement, a collective agreement or concerted practice, we say is clearly the case, clearly fulfilled for the purposes of VISA's UIFM. Now, VISA might seek to rely on the permissive nature of the language which it proposes to incorporate into the rule. But my lords, it is absolutely central to competition law that you do not read this as a contract. You do not read an agreement for the purposes of Article 101. You don't pass it as a contract, a past contractual language. You look at the agreement in the economic context, and you look at it in the reality that exists. And the fact, and one knows why that's the case, because undertakings know they're not supposed to enter into these types of agreements, so they're not going to put an agreement on its face, clearly an anti-competitive agreement. They're going to try to disguise it. So, the permissive nature of the language, we say, it's, first of all, wrong to rely on the permissive nature of the language, but also we know that as a matter of fact, it's totally illusory. It's expressed in that way. But everyone knows, VISA knows, the issuers know, the acquirers know, the effect of that and what is that the issuer will apply an interchange fee. And in reaching that conclusion, you can't ignore the history, quite apart from the incentives that I've explained. It's not a rule that's suddenly been applied out of nowhere. It's a replacement for a default MIF settlement rule. Now, VISA might also seek to rely on an argument that this, instead of setting a figure for a default MIF rule, as the default MIF rule did, the unilateral interchange fee model rule leaves it for the issuer to decide on the level of the interchange fee to be imposed. Ostensibly, on its face, anyway. But I make 2 points about that. First, again, that is an illusion, because everyone knows, you can't ignore the history or the incentives that arise, and you cannot ignore VISA's own evidence on this point, that the fee will be set at the maximum allowed under the Interchange Fee Regulation caps. So the fact that's not specified on the face is, I say, again, neither here nor there. But second, and perhaps more fundamental, is this point. The more fundamental point is, I hope you have now seen from the Supreme Court's judgment and the Courts of Appeal's judgment, is that it is not the setting of a particular level of fee which is the objectionable restriction for the purposes of Article 1011. As the Supreme Court and Court of Appeal made clear, the objectionable restriction is the imposition of a non-negotiable interchange fee in itself, a minimum reservation price. That is the charge that is immunised from competitive bargaining, and that is the charge that acquirers know they can pass on in full to merchants and do, and that is the charge that merchants have no ability to negotiate down or away. And the contrast is between a situation where that collective charge is imposed and a situation where it is not, where there is competition on the whole of the price. So it is the fee itself that is objectionable rather than the particular level of any fee. The particular level of any fee may go to issues under 1013. So it may be that the fee at a particular level can be justified or can be counterbalanced, the benefits from that counterbalance the restriction. So it is relevant to 1013, it is not relevant to 1011. And we say, here, in the unilateral interchange fee mechanism proposed by VISA, third distinction might be, well, under the default MIF rule, the fee was imposed by VISA pursuant to the collectively agreed rules. Here it's imposed by the issuers pursuant to collectively agreed rules. And we say it is still, therefore, an agreement or concerted practice for the purposes of 1011. So moving from VISA's unilateral interchange fee mechanism, UIFM.
Just before you move away from that, you twice said that the rule was illusory in permitting each individual issuer to set their own interchange fee. And I'm just wondering what you mean by illusory. I mean, that's what...
Perhaps illusory is not quite the right word. It will never be used in that way, as we know. There is, on the face of the rule, an option.
Yeah, well, that's the point,
But-
isn't it? I mean, your case is you change the rules, so you give an option, but everybody knows that in fact what's going to happen is they'll set the fee at the IFR.
My lord, yes.
So I mean, is it your case that they couldn't, that any attempt to set the fee by any issuer, unilaterally or otherwise, to set the fee at the IFR will fall foul of this?
Well, I don't need to go so far, my lord, because here there is a scheme rule that appears as part of the collective arrangements between issuers and acquirers and the scheme. So I don't actually need to go that far, not for the purposes of the UIFM. And I don't need to go that far, as well as I'll explain, for the purposes of Mastercard's bilateral arrangements. Because the schemes aren't perhaps brave enough to completely
Well,
leave
your
open.
case is that the only change the rules that wouldn't fall foul of Article 1011 is a change that says zero MIF and settlement in part.
Yes, ma'am. We say that's we say that there's counterfactual against which you need to.
Yeah, but equally, that's the
compare.
only.
Well, we say in that situation it is perhaps it's the next stage, which is you might say, and we don't need again to make this argument for the purposes of today's appeal, but you might say that having considered that as the correct counterfactual, it is inevitable that the result will be that the effects of the actual versus the counterfactual are that it does have this anti-competitive effects. But for the purposes of the arguments I'm making today, which go to the counterfactual, against which that comparison has got to be carried out, and which go to the nature of the arrangements, we don't need to make that next step. It may be that it is inevitable, but we don't need to.
My lord's point is right. I mean, logically, the counterfactual is a rule which says we're not going to set the MIF for you.
Yes.
You choose your own MIF.
Yes.
Now, you can't have anything on the face of it that's more,
Yes.
that's less restrictive than that. It
Well,
says
my lord-
it's entirely up to you which MIF you
Absolutely.
set.
Well, my lord,
Your point is, in the real world, we know, they know, everybody knows, they'll all do the same thing. And they say, well, yes, that's fine, but they're all doing the
So-
same thing
so-
independently. And you
So
say,
the fault lies in giving them the option, because they know that by giving them the option, they'll
Yeah.
all do the same thing. So that does amount, it's like a nod and a wink, isn't
Yes.
it?
Well, my lord, we
but
do.
it does logically follow
Yes, it does, my
that
lord.
the only default rule that you say is not anti-competitive, is not full foul of 1011,
Yes.
regardless of 1013, is
Yes.
one which
What-
says you have to settle at par.
Yes, my lord. That, I don't need to go that far, but it may be the result. But my lord,
I think you
if
need
you're
to go that
concerned,
far.
my
think
lord,
we're
that
saying
does not
logically that's the
necessarily,
logical
yes.
consequence of your
My lord,
argument.
that does not necessarily mean a default MIF rule is unlawful.
Why
It is
not?
only unlawful if it cannot be exempted
Oh,
under
the
1013.
1013. Yes.
So your lordship's concern that this effectively means that such a rule would be unlawful.
No, I didn't actually say
Yeah.
unlawful, I
Well,
said in
no, I
breach
know,
of
but my lord,
1011.
yes, it's my,
It would be anti-competitive, but you might still be able to justify it if there were
my lord, yes,
sufficient benefits,
yes.
fair level of benefits
Yes,
for
my
the
lord,
consumers and
yes.
so on.
It does not mean that this cannot exist. It might be, and we've got, that's a fight for another day, that the schemes can say that either the rule at the level it's currently at, the MIF at the level it's currently at, or at a different level, can be justified as a result of the benefits it brings. So it doesn't necessarily mean it's unlawful.
Sorry,
Well,
just to be absolutely clear, I follow the point about not being
Yes,
unlawful,
ma'am.
but it is your case that a counterfactual using the UIFM would have infringed Article 1011.
My lord, we say that must be the result when one applies the Court of Appeal and Supreme Court judgment, because the only way that you can, the Court of Appeal and Supreme Court judgment are of course binding on the schemes, and the schemes have, or at least MasterCard certainly has, accepted that the fees imposed, the domestic consumer and the domestic intra-EEA interchange fees imposed before the introduction of the IFR do breach 1011. We say there is no basis in there is no basis to introduce a new counterfactual to say that that binding finding of the Supreme Court and Court of Appeal does not apply equally after the introduction of the IFR.
And I quite follow, you say, well, it's all been determined.
Yes.
Supposing that weren't the case, you would presumably nevertheless say that a counterfactual using the UIFM infringed Article 1011. I mean, you'd say that it isn't just that that's been decided, but that is right as a matter of competition law. So why is that right as a matter of competition law?
Because of the analysis that I took your lordships to in the Supreme Court judgment, paragraphs 95 through to 100. One, because of the binding effect of the Court of Justice appeal, judgment.
I follow all that,
And-
but
and
just
to
getting
the
through to
reasons.
the reason rather than
Well,
the decision.
yes, of course, and it is actually, as I say, set out extremely clearly and extremely helpfully in that very short passage of the Supreme Court's judgment.
95 to 101.
Yeah, if you go back to Authorities Bundle 3, tab 13,
I mean, the snag with just looking at that is
Yeah.
that that's against a background where you don't have the IFR. So in understanding whether the same reasoning
Yes, my
applies
lord.
where you do have the IFR,
exactly, my lord, because this reasoning does not turn in any way on the level of the interchange fee imposed. The reasoning of the Supreme Court in paragraphs 95 to 100 does not in any way differ if the interchange fee is at 1.5% or whether it's at 0.3% post IFR. Exactly the same reasoning applies. There is and if your lordships would look at the judgment at page 1121, because whatever the level of the interchange fee, it is still an agreement to fix the reservation price in the MSC. So if you look at paragraph 1121, page 1121, paragraph 96, an agreement between undertakings which has the effect of fixing prices is a restriction of competition. It's well established that the prohibition on price fixing extends to fixing part of the price. The relevant selling price is the MSC. So that's the price that the acquirers charge to the merchants. On the facts of found, the effect of the collective agreement to set the MIFs is to fix a part of that MSC, to fix a minimum price floor for the MSC. In the words of Mr. Dryden's AAM's expert economist, it sets a reservation price. That minimum price, the interchange fee, is non-negotiable. It is immunised from competitive bargaining. Acquirers have no incentive to compete over that part of the price, the interchange fee. It's a known common cost which acquirers know they can pass on in full and do so. Merchants have no ability to negotiate it down. Paragraph 103, there's a clear contrast in terms of competition between the real world, in which the MIF sets this minimum or reservation price, fix the part of the price of the MSC, and the counterfactual world in which there's no MIF but settlement of par. In the former, a significant portion of the MSC is immunised from competitive bargaining, allowing to the collective agreement made. In the latter, the whole of the MSC is open to competitive bargaining. In other words, instead of the MSC being to a large extent determined by a collective agreement, it's fully determined by competition and significantly lower.
You said
Now
that paragraph is not dependent upon
No.
the MIF being set at any particular level.
It is correct that the Court of Appeal and the Supreme Court found that on the facts of the case before it, the MIF accounted for 90% of the MSC, generally on the facts. But that was not necessarily a part of that, it is not necessary for the reasoning contained in those paragraphs. Because the point of the reasoning contained in those paragraphs is there is an element of the MSC which cannot be competed over. There's an element of the price which is not subject to competition, cannot be bargained away.
The trouble I have with this is that what we're considering at the moment is a world where there is no default MIF. We're
Yes,
considering a world where it's up to an individual issuer to say in advance whether or not to impose an interchange fee, or alternatively under the MasterCard model, there's nothing about that at all. And one then has to ask, you say, well, that world, supposing it had existed, would itself have infringed competition law?
yes.
And I'm not sure I get from this exactly why that would be the case,
Well, there's
because there wouldn't be a collectively agreed default figure, and we know that in fact the death spiral argument wouldn't apply either. So what would be the infringement of competition?
There may not be a particular figure which is collectively agreed. There may not be X percent which is collectively agreed. What there is agreed, and this is what I'm trying to say about the collective nature of the agreements under the UIFM, and I haven't yet addressed MasterCard's bilaterals. What is agreed in my submission is that there will be an interchange fee.
It doesn't say that in terms, it says
You have an option.
Well,
you
my
settle
lord-
at par unless you decide to impose one.
Well, exactly, my lord, but that is the point I've been trying to make.
But you will impose, everybody knows you will impose one.
Because, and then one reads the words, and this is where, with the greatest respect, my lord, one needs to step away from the way in which one interprets contracts for the purposes of English law to looking at what is an agreement or a concerted practice for the purposes of European law. You need to look at the arrangements as a whole, not just what's said on the face of the rules, but they're in their factual, historical concept, but also in the fact, in the context of these rules are this particular rule is operating in a whole set of rules that are agreed between the issuers, acquirers, and the schemes. There is obviously an overarching collective arrangement, because that's been held to be so by the Court of Appeal and the Supreme Court, the rules that apply to all of the parties operating in these markets. And one of those rules is going to be, under the VISA's unilateral interchange fee mechanism, you can do this, tell us if you do it. You can impose an interchange fee. Tell us if you impose an interchange fee, what level it's going to be, and you've got to publish it.
So just to be
What's
clear,
that rule going to do? That rule is going to have the effect of them imposing an exchange fee.
so that rule would itself be objectionable.
My lord, yes.
The rule that you could choose to impose a fee provided you gave notice of it would be
Yes, my lord,
objectionable
because
measure.
although those are
May I
the,
come back to the point that we put to both my Lord Justice Newey and I put to you, which is that the logical consequence of that, you may be right, you may be
Yes.
wrong, but the logical consequence is that nothing other than a rule which says thou shalt not impose a MIF full stop and thou shalt settle at
Yes.
par is ever going to be anything other than anti-competitive
my lord,
under
yes.
Article 101.
Under 1011, yes.
I follow the point about 1013, and that's mercifully a battle for another day.
It is, my lord, yes. And we say, yes, we say, and that is, that decision, that case, that has already been decided by the Supreme Court, but yes, that's our position.
Can I, sorry,
Yes, it's not just because one needs to look at, in interpreting these words, what the rule says on its face, and we're still here on the VISA unilateral interchange fee mechanism. In looking at what the rule says in its face, on its face, one needs to look at not just, first one needs to look at the history as to what it might actually mean, rather than what it says on its face. And the history is that the rule has been, up to now there has been a default MIF settlement rule. So that's the history on which you read. On its face it says you can do this. What does it actually mean? Yes, you can do it. So that's the history, is the first point. The second point against which you've got to read these words is to look at the incentives created by the framework of the rules. The rules create a framework, a framework that is collectively agreed to by all the parties. And one of those collective rules to which they all sign up is this unilateral interchange fee mechanism rule. So it's clearly a rule that's collectively entered into by all these, by the issuers, the acquirers, and the schemes. And it's a rule, we say, that restricts competition, because when one looks at the world in which this collective arrangement is in place, even though the collective arrangement says something, you look at a world in which it's in place versus a world in which it isn't in place, the UIFM, and you come to the conclusion that it has an anti-competitive effect. But it is clearly a rule imposed collectively because it's a part of the scheme rules that are agreed to by issuers, acquirers, and the scheme. It's not a unilateral conduct. It's not unilateral conduct by the issuers. It's a rule they sign up to.
can I suggest this to you, going back to the Supreme Court judgment at paragraph 99. On those facts, where there was a default MIF rule, they said the effect of the collective agreement to set the MIF is to fix a minimum price floor for the MSC. Is it too simplistic to reduce your case to, on the UIFM, it would have the same effect in the real world, given all the incentives and the way in which people know that they will operate it, even though in terms it gives people a choice.
Yes.
It gives the issuers a choice, but the same effect is to fix
It would, my lord. It
the
is.
minimum price floor.
Yes, yes, my lord. Prior to that, is it a rule that's agreed to collectively? Yes, it is, because everyone signs up to it, issuers, acquirers, and the schemes. What effect does it have? It has exactly the same effect as set out in the Supreme Court's judgment.
Thank you.
Well, I mean, in a sense, you say that paragraph 13 of Mr. Livingston's statement really gives the game away, doesn't it? Because it says that this is what everybody would be likely to do because they all want to maximise their interchange fee revenue.
Yes.
And that's something they're entitled to do, or they can exercise the option to do it.
And they will.
Unless somebody tells them that they can't do it at all. And that's essentially your case.
So it is important that I move from the VISA's unilateral interchange fee model to the MasterCard's proposal for
Shall we have a
bilateral.
break now then?
Yes,
and,
let's do the
in
bilateral.
5 minutes time. Bang on the door again.
Very soon, so.
12:17. Oh, except
Yeah. Definitely.
Fundamental philosophical difference.
I saw him this morning.
That'll be fine.
That's it.
So same the gospel. We both have the same genuine scope. That's right.
Okay, at the end of the day, just usually we stay in it, and then I'll let security know that.
Just need to.
not take decisions individually.
Silence for all ayes.
So my lords, before I move on to ground two, I need to address the MasterCard's proposed bilaterals arrangement. And specifically under ground 1B, whether this is these are collective arrangements for the purposes of Article 1011 rather than unilateral conduct. Specifically the involvement of MasterCard in those arrangements. Can I start by just taking you back and reminding you of what those arrangements are proposed to be, which is Supplementary Bundle 1, Tab 12, which is, you've been here before, Mr. Crozal's witness statement. And specifically, I would like to take you to, I've taken you to 17 through to 22, I'd like you to take you back to paragraph 22 on page 246.
Yeah.
Which is where Mr. Crozal says what it would be realistic for us to do and what we would do in a post-IFR world is not to set any default settlement rules and instead leave issuers and acquirers to negotiate bilateral agreements and the level of compensation to be provided pursuant to them. They, the issuers and acquirers, could have done so in advance. Alternatively, they could agree a fee after the transaction. And then she says, last sentence, in my view, it is inevitable that this would have resulted in interchange fees being agreed bilaterally at the level of caps, with the issuer demanding the highest interchange fee it could, but no more. So there is, under MasterCard's proposed bilaterals arrangement, there is nothing in the scheme rules. It is left to a series of bilateral agreements entered into by issuers and acquirers. So at first sight, my lord, this sounds quite seductive. Here are a number of agreements, bilateral agreements, apparently freely entered into by issuers and acquirers and apparently without the involvement of the scheme. That has to be the case for MasterCard to say that these are not collective arrangements. But, although that, my lord, sounds seductive, again, I say that ignores the reality of the situation. What it specifically ignores is that these bilateral arrangements are not going to be entered into in a vacuum. They are said to be being entered into, or they would be entered into, against the background fact that the issuers, acquirers, and MasterCard have all agreed to the scheme rules. And those scheme rules, which are a collective agreement between issuers, acquirers, and MasterCard, will continue to be in existence after the introduction of the Interchange Fee Regulation. So it is against the background of those collective arrangements that these bilateral agreements will be entered into. And those scheme rules, those collective arrangements to which all the participants in the various markets have agreed, well, at least the issuers, acquirers, and the MasterCard have agreed, include the honour all cards rule. And you'll recall, just for your note, that those, I've shown you these references, the honour all cards rule are described in paragraphs 553 of the Commission decision and in paragraph 18 of the Supreme Court's judgment in MasterCard, and I've already shown you those. But in summary, the honour all cards rule, which is part of the collective arrangements in the scheme rules, requires acquirers to process and merchants to accept all MasterCard card transactions falling within any particular category of cards presented to them regardless of which issuer issued the cards. So the honour all cards rule means that acquirers have to process and merchants have to accept transactions under all MasterCard, for example, debit cards, regardless of who issued those debit cards. So they have to accept Barclays MasterCard debit cards, they have to accept Co-op MasterCard debit cards. That honour all cards rule, which is part of the collective arrangements between the schemes, the issuers and the MasterCard, the issuers and the acquirers, continues.
And that, have I got this right? You say, well, one effect of that is that they will set their interchange fees at the IFR, which is the highest level they can go to, because they know that they can pass all that on to the merchants, because the merchants have to honour the cards.
But it
So
goes
it's
deep.
not open, for example, I know Sainsbury's aren't a party to these proceedings, but it's not open to a large supermarket chain or whatever to say, well, we'll take cards from Barclays and Lloyds, but we won't take them from HSBC or something like that,
Absolutely, Mike.
because their interchange fee is too high or something.
Yes, absolutely. But the point goes even deeper than that, my lord. MasterCard's bilaterals arrangement, counterfactual, is presented to you as being leaving it to issuers and acquirers as to whether they want to enter into bilateral agreements. They have the freedom, I think it said, to enter into bilateral agreements. But the reality is, under the scheme rules, under the honour all cards rule, if acquirers want to accept any MasterCard debit cards, they have to enter into bilateral agreements with all issuers. Because if they want to offer or they want to process transactions with Barclaycard debit cards, they also debit MasterCards, they also have to, they are required under the honour all cards rule to also accept transactions under Co-op MasterCard debit cards. So they are required, if they want to accept any MasterCard debit cards at all, they have to enter into bilateral agreements with issuers because of the operation of the honour all cards rule, because of the operation of the scheme rules. There is no freedom to enter into bilateral agreements whether they want to or not, because of the operation of these collectively agreed scheme rules, which include the honour all cards rule. The bilateral agreements and the scheme rules are therefore inextricably linked. They cannot be considered separately. Because as an acquirer, you have to enter into agreements with issuers in order to accept any MasterCard debit cards.
Because on this scenario, you don't have a default rule, so there's no obligation on issuers to settle at all unless they enter a bilateral agreement, is that right?
They have to enter into a bilateral agreement, yes. Why do they have to enter? They have to enter into bilateral agreements because otherwise they would not be able to accept transactions with MasterCard cards. It's not a freedom to go out there and enter into a bilateral agreement if they want.
No, the issuers are free to choose whether to enter into bilateral agreements, but they have no incentive not to.
Exactly, my lord. And they've already also agreed to the scheme rules, which include the honour all cards rule, because they have no incentive not to.
Well, they know that any acquirer can make an agreement is going to be obliged to honour their cards.
Yes. Well, they know more than that.
So
They know that when they enter into a bilateral agreement with the issuer Barclaycard the issuing bank know that when they enter into an agreement with an acquirer, to process their transactions, the acquirer will have to enter into bilateral agreements with every other issuing bank as well, under the rules. So they know that everyone else will be entering into bilateral agreements and are required to do so under the honour all cards rule. And they also know, because we're told by Ms. de Crozals, and it's in their economic interests and incentives to do so, that those bilateral agreements will include a requirement to pay interchange fees, and they will include a requirement to pay interchange fees up to the level of the cap. And when we stand back and say, are there collective arrangements between the scheme, the issuers and the acquirers under MasterCard's proposed bilaterals counterfactual? Yes, there is. Because although the actual bilateral agreements are only entered into between issuers and acquirers, they are enmeshed with the scheme rules and required pursuant to the scheme rules, which are entered into between the issuers, the acquirers and the schemes.
It is really the honour all cards rule which causes the
It's a
anti-competitive effect.
Fundamental part of the setup. It enables this to happen.
If you didn't have that rule, then as my lord said, a supermarket could say, we're only going to accept MasterCards from A, B and C and not from D, E and F. Because
It is a fundamental part of the
Everybody would get their cards from A, B and C, and the other people would go out of business.
And so, my lord, as you see in the paragraphs, if you could cast your mind right back to the very beginning of this morning, when I took you to the paragraphs in the Supreme Court judgment and the Court of Appeal judgment describing the schemes and the setup, one of the rules, as well as the default MIF settlement rule that was highlighted by the Court of Appeal and the Supreme Court, was the honour all cards rule. I think it's paragraph 4 of the Court of Appeal's judgment, because it is an integral part of the whole setup. So, my lords, I think then
So your point is it's not actually the presence or absence of the default MIF rule by itself which has these effects. It's the set of rules as a whole which has the effect that a minimum price, reservation price, will end up being set.
when you focus in on that particular rule, the default MIF settlement rule, you cannot just look at it in isolation.
Yes, but in the counterfactual, the MasterCard counterfactual, there isn't a default MIF rule. There's no default settlement rule at all. It's just entirely left to the bilateral arrangements.
In the
You-
MasterCard counterfactual.
Your case is that all the other rules force the bilateral arrangements into one particular type, which
Yeah.
has
Well,
which
they-
has the effect of setting a minimum price.
They
floor.
don't just
Unless
force
you
them.
impose a rule that says you can't.
Yes. They don't just force the arrangements into one particular type. They force them into making the arrangements in the first place. So, my lords, if I can move then to ground 2, which I hope, having set out this background, I can deal with a lot more quickly. And I'm going to have to. Ground 2 applies to inter-regional MIFs. Those are, as I have explained, the MIFs charged, or the particular interchange fees, the particular level of interchange fees, charged on transactions when an issuing bank is in a different region of the world from where the merchant, where the card is presented. So not within the EEA, but in different regions. So when an American cardholder comes to the UK and buys something in Sainsbury's down the road, they have a card issued by an American bank, but they're using it with a UK-based merchant. That transaction will be subject to an inter-regional interchange fee. This argument is wholly independent of, it's completely different from the pre-IFR and post-IFR period arguments. VISA and MasterCard argue that because the claims in the 3 cases which went up to the Court of Appeal and the Supreme Court in the MasterCard judgments that we've been looking at, only claimed for damages suffered as a result of the imposition of domestic MIFs and intra-EEA MIFs, the Supreme Court and Court of Appeal judgments are not binding insofar as a claim is made based on the payment of inter-regional MIFs, because they are only applicable to domestic and EEA MIFs. And some of the claims, or part of some of the claims made by some of my clients, are for inter-regional MIFs. And this doesn't matter whether the MIFs were imposed before or after the IFR. This argument by Visa and MasterCard applies equally before the IFR as it does post, so we can leave the IFR to one side. Now, the tribunal below held that it was not bound by the Court of Justice judgments or the domestic appeal judgments to find that interregional MIFs infringe 1011 because they are potentially capable of being factually distinguished from those cases on the basis the tribunal said that such a MIF does not set a minimum price floor for the merchant service charge. And this points are probably made best by reference to the tribunal's judgment. So if I can ask you to open the tribunal's judgment, put away the supplementary bundle 1 and look at the tribunal's judgment, which is in the core bundle, tab 5. And the section on interregional MIFs starts on page 163 of the bundle. And you'll see there the heading towards the top of the page, interregional MIFs, commercial cars and Italian domestic MIFs. We only appeal as regards interregional MIFs. And you'll see the argument in paragraph 54. These MIFs were not the subject of any of the prior decisions, in the way I've explained, in that the claims under the prior judgments were only claims for damages resulting from the imposition of these other types of MIFs. I will argue that they're not the subject in that the reasoning applies equally to these MIFs, but both Visa and MasterCard submit that each of them differ substantially from UK, Irish domestic and EA consumer MIFs in ways that are material to the analysis of restriction competition. They contend they have distinct defences to the allegation that those MIFs, even if set by collusive arrangements, had an appreciable effect on competition, which defences are strongly arguable and therefore sufficient to preclude summary judgment. In support of those contentions, both Visa and MasterCard filed expert economist reports. And we didn't, for the purposes of the summary judgment application, file any expert reports in return. But, my Lord, if I can take you to paragraph 59 on page 165 of the tribunal's judgment. They there set out paragraph 93 of the Supreme Court's judgment, which precedes the paragraphs we've been looking at, but it is the paragraphs where the Supreme Court holds that it is bound by the decision in the Court of Justice. You'll recall in 95 to 100 it then goes on to say, in any event we hold that they are restricted by effect, but it's in the section of the Court of Appeal's judgment where the Supreme Court holds that they are bound by the Court of Justice judgment, and they say that, you'll see in paragraph 59 of the tribunal's judgment, the Supreme Court reiterated the findings on which MasterCard Court of Justice is based were not distinguishable from the facts found or accepted in the cases before it, and summarised those findings at paragraph 93, which we have already quoted but repeat here for convenience. And in paragraph 93, the essential factual basis of the Court of Justice's judgment is set out by the Supreme Court, and they say it's mirrored in these appeals. If I just ask you to read paragraph 93 again. And to focus specifically on paragraph 93, little Roman 2, which we have called fact 2 in our skeleton argument. That is that the MIFs in the Supreme Court's case have the effect of setting, the MIF has an effect of setting a minimum price floor for the MSC. Now, MasterCard and Visa argued in front of the tribunal that fact 2 was not fulfilled as regards interregional MIFs. Basically because they say that interregional MIFs, which are generally higher, much higher, and are not in fact subject to caps under the IFR. They are a lot higher than the domestic and EEA MIFs. When looked at, those interregional MIFs are sometimes higher than, or sometimes, sorry, get this the right way around. The merchant service charge paid by a particular issuer is sometimes lower than the level of the interregional MIF.
Paid by a merchant.
Sorry, paid by the merchant service charge paid by the merchant to the acquirer is lower than the interregional MIF. Therefore, the schemes say the interregional MIF cannot set a floor to the price of the merchant service charge. And this, as we explain in our skeleton, well, first let's step back. It's accepted as a matter of fact that a merchant service charge is calculated in a number of different ways, depending on the merchant you're dealing with. Larger merchants might be able to have more bargaining power vis-a-vis the acquirer, so they negotiate a different merchant service charge. There are generally two types of merchant service charge. There's a merchant service charge which is calculated on what's called a MIF ++ basis. And that is where a merchant has an agreement with the acquirer, where the merchant service charge is explicitly set as being the sum of the MIF plus the scheme fee plus a fixed acquirer's margin. And we say where merchant service charges are set for interregional transactions on a MIF ++ basis, we say it's beyond argument that Fact 2 applies, because it is clearly the case that in a MIF ++ arrangement, the interregional MIF sets a floor.
But in a MIF ++ situation, the MSC couldn't be lower than the MIF, could it?
No, exactly not. In that situation, it can't. Although across the board, averaged out, the MSCs
Well, that's
might
a
be lower
different point
across the
about
industry, but
that.
that's a very different point. And the evidence adduced by the card schemes to the tribunal explicitly recognised this. If I could ask you to look at paragraphs 63 and 64 of the tribunal's judgment, which is on pages 166 and 167 of the document, which I think we still have open. And you'll see at the top of page 167, Mr. Holt for VISA notes that the average MIF for interregional transactions was significantly above the typical MSC for debit and credit cards in the UK. Well, I think that's the point already made by my Lord Justice Flo. Yes, on average, when averaged out across the board, taking into account MIFs ++ and others, that might be the case. What's a little more instructive is what's said by Dr. Niels in paragraph 64.
Yeah.
Where he says, which is reproduced in paragraph 64, 3.7, small volumes of interregional transactions call into question whether interregional MIFs would constitute a price floor. It is likely that in many situations, particularly in sectors with few interregional transactions and in the absence of MIF ++ contracts between the acquirer and a given that, and then you'll see footnote 7 at the end of that quote, where an MSC for any transaction is set to the sum of the interchange fee scheme fee for its acquirer's market. Acquirers will not have set separate MSCs for interregional transactions, and the MSCs would be set with reference primarily to the domestic MIFs and the acquirer's own costs. In such a circumstance, he said, there's no price floor effect. And again, he makes the point that there's no price floor effect in the absence of MIF ++ contracts in the second line of the following paragraph. And
You said there were two types of...
yeah, so that's
MSC,
the so
second
he
one is-
explicitly says my reasoning does not apply to MIF ++.
Yeah.
The second is a blended MSC, which is that where the MSC is set by reference to a blend of all the interchange, which is set by reference to all the costs. incurred by the acquirer, and therefore all of the MIFs paid. So you can see that a merchant generally will accept a mix of transaction types, inter-regional and domestic EEA. It is common ground that the inter-regional transactions are likely to form a small part of the transactions. That's paragraph 63 of the tribunal's judgment. Inter-regional transactions constitute only a relatively minor part of merchant transactions compared to domestic and intra-EEA transactions. So if you are setting a blended MSC, the MIF element is a small part, and averaged out across the board, it may very well be that when you average it out together with domestic MIFs, which are a lot lower, and intra-EEA MIFs, which are a lot lower, you could end up with an MSC for each individual transaction that is lower than the particular MIF for that transaction. And also, and I'll take you to this, it may be the case that acquirers are able to negotiate a fee that down below the level of a particularly high MIF. Now, however, it is the case that even in that situation, the card schemes themselves accept the prices acquirers charge to merchants through the merchant service charge take into account the MIF. And I can take you through all the pleadings and the evidence, or I can just take you to our skeleton argument where we give you the cross-references. And our skeleton argument at paragraph 17, core bundle 3, sorry, core bundle tab 3, page 118. And if I could ask you to read paragraph 17 at the top of that page. And that gives you all the cross-references and the cross-references to the pleadings and where they are in bundles. I'm not going to take you to each one.
Sorry, page?
Page 118 of the
Yep.
bundle. At the top of the page, paragraph 17, we make the submission in our skeleton by reference to, and you'll see footnoted at the bottom of the page, the pleadings, in fact the pleadings, not the evidence. The prices acquirers charge to merchants through the MSC take into account, even if not fully, the MIF. And the pleadings are slightly different for Visa, as they are for MasterCard, but both of those schemes, we say, admit that the prices acquirers charge through the MSC take into account the MIF.
Those pleadings are not specifically in relation to these intra-regional MIFs, they're just to MIFs generally.
Across the board, yes.
Do they plead specifically in relation to the intra-regional MIFs?
There is no particular pleading in that regard, no, except they say the markets are different. The
As I understood what Dr. Niels was saying, he was making the point that they don't usually bother setting a different MSC for inter-regional transactions.
That's right.
They
No,
just
they
charge the same one as for everything else.
Exactly. Now,
So inevitably the MSC does take account of the MIF.
yes, that's our point. Now, the concern of, and that really is our point, the concern of the tribunal, just to try to deal with this point, appeared to be, and I'm paraphrasing here, that for some merchants there will be so few interregional transactions that the effect of the interregional MIF on the MSC is de minimis, and so it's not appreciable. But it doesn't address the fundamental point that even if blended MSCs are equivalent to or lower than the relevant MIF, the price charged, but through the merchant service charge, is still not fully determined through competition, the MSC price. And I think I will jump immediately to the reasoning which we adopt, because it's clearly set out in the Commission decision on MasterCard, where a very similar point was made by the schemes in that decision, in those proceedings before the Commission and the General Court as regards. Similar arguments were made by MasterCard regarding the position in Spain. So if I can take out the Commission's decision, which is at Authorities Bundle 1, tab 1A.
Page.
Page 189.23. And this is under the heading D. Acquirers may sometimes absorb MIF, Spain. I could ask your lordships to read paragraphs 449, 450, and 452, which goes over the page. Well, in fact, to read them all up, it's a short section, if you would, my lord. 449 through to 452. So, my lords, I say there are two lines of reasoning mixed up in those paragraphs. There's the reasoning. Well, first of all, the Commission comes to the conclusion that the fact that in Spain, MSCs often fall or sometimes fall below the level of the MIF still means that they are a restriction. And there are two lines of reasoning which lead the Commission to that conclusion. The first is an assessment of the facts, and that you'll find in paragraph 451 and the beginning of paragraph 452. And on the facts, the Commission says the absorption of the MIF by acquirers is very exceptional on the facts, and it goes on to say what it found on the facts. And it goes on to say the situation in Spain is specific for two reasons on the facts. So it comes to that conclusion on its assessment of the facts. But the second line of reasoning, my lord, and that is the line of reasoning on which we rely, is that the Commission also comes to the conclusion that even where MSCs fall below the level of a particular MIF, they are still a restriction as a matter of principle. And that line of principle, legal reasoning, is found in paragraphs 450 and the second part of 452, and we rely on that aspect of the Commission's reasoning in these paragraphs. 450, they say this, that is the fact that there are cases, as recorded in the previous paragraph, where acquirers grant merchant MSCs below the level of the MIF. This is no reason why the MIF would not be caught by Article 101(1) of the treaty. Even if an acquirer may choose to absorb a portion of the MIF still inflates the acquirer's MSCs by a certain extent. The price is still not fully determined through competition, but to a large extent by a collective decision among or on behalf of the banks. And then over the page, the second part of paragraph 452. Taking into consideration the existence of hundreds and even thousands of different domestic MIF rates in Spain, that was the situation in Spain, we would say for which read hundreds or even thousands of different, or a number of different MIF rates, including the interregionals, an acquiring bank will blend those rates into one or a few MSCs. Inevitably, a blended MSC will be an average of all interchange fee rates, and therefore sometimes lie below certain interchange fee rates. Even in this specific situation, banks can be expected to consider the domestic MIFs as an input cost in calculating a weighted MSC. So we rely upon that aspect of the Commission's reasoning. And that was upheld by the General Court and the Court of Justice, and we say is in any event correct. That is the General Court judgment at the following, tab 4 of Authorities Bundle 1, page 258. to page 258, if I could ask you to read paragraphs 164 and 165. And again, my lord, we say there are two strands of reasoning here. That on the facts, as regards the position in Spain and the investigation that's carried out on the facts, but also a line of reasoning as a matter of principle, and that's contained in 164 and the last sentence of 165. Even in such a case, the banks could reasonably be expected to be in a position to offer lower MSCs in the absence of a MIF. So, my lord, for your notes, this conclusion of the General Court, which is upheld by the Court of Justice in paragraph 193 of its judgment, is not merely based on an assessment of the facts as the tribunal held, but it is based on principle, and we rely upon those principles to make the argument that even in the case of a blended MSCs, the interregional MIF is still provides a price floor, a minimum price floor for which read an element that is not subject to competitive bargaining, and therefore you can't distinguish the case of interregional MIFs from the case considered of the other types of MIFs that were part of the claim, form the basis of the damages claimed in the other cases. The fundamental point, again, it brings us back to, is that as I have argued, and I'm not going to go back to the judgments, but the Court of Justice, the Court of Appeal and the Supreme Court in their previous judgments were not concerned with the level of any particular MIF. The anti-competitive restriction which they identified was the imposition of an interchange fee in and of itself, which fixed part of the price for the merchant service charge charged by acquirers to merchants, which is non-negotiable and immunised from competitive bargaining. That reasoning applies equally to interregional MIFs, which are taken into account by the schemes in setting their MSCs, just as it applies to the other types of MIFs for which claims were made in the cases before the Court of Appeal and the Supreme Court. So, my lord, we therefore say that the situation of interregional MIFs cannot be distinguished on the facts from the decisions made in the Court of Justice, Court of Appeal and Supreme Court. There's no argument here about pre or post IFR.
No.
In this ground too, as part of their respondents' notice, MasterCard also seeks to rely on a PSR report which was published after the CAT's judgment, and I may, with your permission, come back to that in reply once I've heard his submissions on that. And also Visa and MasterCard in their respondents' notices on ground 2 also rely on further arguments above and beyond those contained in the tribunal's judgment as to the nature of competition on interregional MIFs, and MasterCard, I think specifically, I may have got that wrong, makes an argument on objective justification and ancillary restraint specifically for interregional MIFs. But again, with your permission, I'll come back to that in reply once I've heard what they have to say. And I will also address, of course, Visa's cross-appeal in reply. So, subject to that and subject to any further questions from your lordships, those are my submissions.
Thank you. Thank you very much. Right. Mr.
My lords, can I begin by summarising for your lordships what the issues are and to identify for your lordships also who from the Visa team will be addressing you on each of them. First issue, as your lordships have just heard from my learned friends, is whether the tribunal was right to refuse summary judgment in relation to the period after the 9th of December 2015, and which amounts to the same point, to grant Visa permission to plead its alternative counterfactual for that period. That's obviously the UIFM point which my learned friends just addressed. It's ground 1 of my learned friends' appeal. I'm going to be addressing your lordships on that, and for your lordships note, we deal with this topic at paragraphs 29 to 46 of our skeleton core tab 11, pages 225 to 231. The second issue on which I'm also going to be addressing your lordships, again subject to your lordships being happy with this way of proceeding, is whether the tribunal was right to decide obiter that Visa's defence for the period from 21st of June 2016, based on Visa Inc.'s acquisition of VISA Europe, was not arguable and should not go to trial. We've called that the Visa Inc. issue, and your lordships will recall this is ground 1 of Visa's Respondents Notice, core tab 10, page 205. And again, as I say, I'll be addressing your lordships on that topic. We, as your lordships know, respectfully say the tribunal was wrong to reach the obiter conclusion that it did on that issue. And again, for your lordships notes, we deal with this topic at paragraphs 50 to 57 of our skeleton core tab 11, pages 232 to 235. The third issue is whether the tribunal was right to refuse summary judgment in relation to the interregional MIFs on the basis that it is arguable, as the tribunal found, that the interregional MIFs are materially different from the MIFs that were considered in the first wave of litigation. Your lordships have just heard from a learned friend on that issue. That's ground 2 of my learned friend's appeal, and Mr. Kennelly QC will address your lordships on that. And it won't surprise your lordship to hear that Mr. Kennelly will say that the tribunal was right to reach the conclusion that it did. That topic we deal with at paragraphs 47 to 49 of our skeleton, core tab 11, page 231 to 232. The fourth issue, and that's closely related to the third, is raised by Visa's Respondents Notice, where, as your lordships might recall, Visa asks your lordships to uphold the tribunal's refusal of summary judgment in relation to interregional MIFs on additional or alternative grounds that summary judgment should be refused owing to different competitive conditions in the acquiring market for the interregional consumer MIFs. And your lordships may recall the tribunal considered it unnecessary to deal with this. Mr. Kennelly again will address your lordships on that, and we deal with that at paragraphs 65 to 67 of our skeleton, core tab 11, pages 237, 238. The fifth and final issue involving Visa before your lordships is whether the tribunal was right to decide again obiter that Visa's defence based on the fact that interregional MIFs were set by Visa Inc. and not by Visa Europe was, as the tribunal found, not arguable. That is ground 2 of Visa's Respondents Notice, core tab 10, page 205. And again, Mr. Kennelly will address your lordships on that. And Mr. Kennelly, I'd be surprised if he didn't say to your lordships that, as with the Visa Inc. issue, the tribunal was wrong to reach the conclusion that it did. If he doesn't say that, I may stand up suddenly. But, for your lordships note, we deal with this at paragraphs 58 to 64 of our skeleton, core 11, pages 236 to 237. So that's a roadmap, and I hope your lordships are content with that way of proceeding. Turning to the first topic, my lords, the UIFM counterfactual issue. Subject to your lordships, I'd like to start, if I may, with our positive case, explaining what Visa's argument is and why. We respectively say that case is at the very least a properly arguable one, as the tribunal found, and indeed one that, as the tribunal concluded, should be permitted to go to trial. And it is, we submit, helpful to introduce this issue by identifying for your lordships why Visa's arguments on restriction of competition failed in the first wave of the MIF litigation, both in the in this court and in the Supreme Court. And in my respectful submission, going through that, your lordships will see what we respectfully submit is the muddle in the learned friend's submission on this issue. Can I start with the Court of Appeal? Because that is the judgment that explains why, in the first wave of the litigation, the settlement at par counterfactual was agreed to be the correct counterfactual. And for this purpose, can I invite your lordships to go to paragraph 126 of the Court of Appeal's judgment. You'll find that Authorities Volume 3, tab 12, page 1033. Now, if your lordships have that, your lordships see the heading, the learned friend I think took your lordships to this, I know she did, discussion and conclusions on Article 101(1). And as your lordships have seen, because my learned friend did take you to this, the court begins by quoting from the General Court's decision in Carte Bancaire. And we would respectfully submit that this is a very important paragraph for the purpose of these appeals, not least because it explains the function of a counterfactual. So just taking this in stages, looking at the first sentence, so your lordship see, the General Court said that the analysis of the competitive situation in the absence of the measures in question aims to determine whether the measures in question, whether the measures restrict the competition that would have existed in their absence. So as your lordship see from that, the point of counterfactual analysis is to determine whether the measures in question restrict competition that would have existed in their absence. Then just reading on, the General Court then tells us that we perform this analysis, this counterfactual analysis, by asking whether, in the absence of the measures in question, the competitive situation would have been different on the relevant markets. Or, in other words, as the General Court puts it, in the final clause of the quotation, the question is whether the restrictions on competition would or not have occurred on this market in the counterfactual. So one has measures in question and one has a competitive situation which arises. The point of the counterfactual is to remove the measures in question and to test the position to see whether the competition concern still arises. Because if it does still arise, then we know that it is not caused by the measures in question. It's caused by something else. It would have been there in any event. And so what the law here requires is that one make a comparison between competition on the relevant market in the real world, in the presence of the measures in question, against, in the counterfactual, competition on the relevant market without the measures in question. And as Carte Bancaire, and indeed the Court of Appeal here, tell us, the purpose of this is to identify whether competition is more restricted in the presence of the measures than in their absence. Putting it the other way, if one observes something that looks like a restriction in the real world, but it is also there in the counterfactual, without the measures in question, then one is able, both logically and legally, to conclude that the measures in question did not cause that restriction. So when one is testing the counterfactual, a la Carte Bancaire, one doesn't remove the competition concern for the purposes of the counterfactual. One removes the measures in question because the whole point of that assessment is to see whether the competition concern still exists in the absence of the measures in question. And with respect, that is where my learned friend's whole analysis goes wrong. Just reading on, in this court's judgment in Sainsbury's, just if your lordships go over the page, sorry, paragraph 127. Your lordships see there, the court goes on to identify the measures in question. In our judgment, the scheme's argument as to the correct counterfactual in all these fundamental propositions, then this, the measures in question in this case are the agreements between the issues and the acquirers to be bound by scheme rules set by the scheme defendants, or put it more simply, the scheme rules are set by the scheme defendants. Those rules set default MIFs payable in the absence of bilateral agreements being reached. So the agreements between the issuers and the acquirers to be bound by the scheme rules set by the scheme of defendants, which set default MIFs payable in the absence of bilateral agreements being reached. And then, just taking your lordship back to paragraph 128, Madam took you to this, your lordship see that the court there acknowledged, VISA counsel submission, that there has to be a rule as to settlement, but said that it didn't have to involve a MIF. One could have a settlement at par rule, which is the same thing as zero MIFs, and the scheme would still function. And that, the court concluded, was what would happen in the absence of the measures in question. And as I'll show your lordships, the court then went on to explain in the passages that followed why that was the correct counterfactual in that case. And I'll also show your lordships the court came to this conclusion by reference to the reasoning of the EU court in the earlier MasterCard litigation. And just on this, there may be enough time, can I ask your lordships to go first to paragraph 142 of this decision on page 1037. I don't think this is a passage that Milena can take you to. So these points were rejected on two grounds. First, at paragraph 132, the General Court said that for the reasons it gave at paragraphs 94 to 120, a MasterCard system operating without a MIF solely on the basis of a rule prohibiting ex post pricing was economically viable, and that was sufficient to justify it being taken into consideration in the context of the analysis of the effects of the MIF on competition. This was the aspect of the General Court's decision that was later said to be wrong by the CJEU, but it demonstrates that the General Court was approving the no MIF plus prohibition of ex post pricing counterfactual, which the CJEU also later approved for slightly different reasons. The no MIF prohibition of ex post pricing counterfactual is not materially different from the no default MIF plus settlement at par counterfactual that the parties are agreed upon in this case. Both admit the possibility of bilateral interchange fees, but assume that in default there will be no imposed standard MIF and also settlement at par. So the General Court, as the Court of Appeal is here explaining, identified the counterfactual as being the rule against prohibiting ex post pricing, and it did so on the basis that that was economically viable. Now that is the test that you would apply for trying to identify a counterfactual in the context of objective necessity and ancillary restraint. As long as you can find a counterfactual which is economically viable, and you test that counterfactual to see whether the scheme would have survived, it is sufficient that that counterfactual is economically viable. But that is not the test that one adopts for the purposes of the counterfactual 41011. For that purpose, you don't simply ask whether the counterfactual was economically viable, you ask what was the likely counterfactual. What is a matter of factual analysis, speculation based on the evidence, was the likely counterfactual. So that is what the CJU said the General Court went wrong about, but it nonetheless concluded that the counterfactual that the General Court had identified for the purposes of ancillary restraint was in any event the likely counterfactual. And if your lordships go over the page...
just to understand, why did they say that was a likely counterfactual?
If I'm going to show that to your lordships now.
I see. Thank you.
I'm sorry, I should have said.
Go over the page.
If you go to paragraph 149,
Yeah.
the CJEU's criticism of the General Court at paragraph 167 was that it had not in any way addressed the likelihood or even plausibility of the prohibition of ex post pricing if there was no MIF in the context of its analysis of the restrictive effects of the MIFs. That was why the CJEU concluded at paragraph 169 that the General Court should not, at paragraph 132 and paragraph 143 of its decision, have relied on the single criterion of economic viability to justify the inclusion of a rule prohibiting ex post pricing as part of its counterfactual. The General Court said that CJEU had no explained whether it was likely that such a prohibition would occur in the absence of the MIF. That was an error of law, but one that the CJEU thought at paragraph 170 would not allow the decision to be quashed if its operative part was shown to be well-founded on other grounds. So it's effectively repeating the same point that I think I just made to your lordships. If I then ask your lordships to go to paragraph 150, the lordships see here that this error of law on the part of the General Court made no difference in that case because the CJU decided that prohibition on ex post pricing or zero MIF was the right counterfactual anyway. And just looking at paragraph 50, one sees that the reason for that was because of the hold-up problem. So I'm just picking this up. The General Court and the Commission had been entitled to conclude that the possibility of issuers holding up acquirers who are bound by the honour roll cards rule could only in effect be solved by a scheme rule prohibiting ex post pricing. So just pausing there, one has the what is described as the hold-up problem. And before the General Court, it was accepted or said that the only way in which the hold-up problem could be solved was by a scheme prohibiting ex post pricing. Such a rule, they said, was less restrictive of competition than MasterCard's existing MIF solution. That led the CJEU to conclude in paragraph 173 that the ex post pricing prohibition could be regarded as a counterfactual analysis that was not only economically viable but also plausible or indeed likely, given that there is nothing in the judgment to suggest, and it is common ground, that MasterCard would have preferred to let its system collapse rather than adopt the solution. And I think I just need to unpack that a little bit. Milena Friend talked about the hold-up problem, but in my respectful submission, she described it in a way which was not consistent with the way in which it's been described by the Court of Appeal and by the European decisions before that. Milena Friend has taken you to Dr. Nell's paragraph 2.8 to 2.10. I'm not going to take you back to that. It's also referred to by the tribunal. I'm very happy to take you back to that because I'm very happy with the way that's put. It's also referred to by the tribunal in paragraph 39 of the judgment. But the problem arises, as I think Milena Friend explained, in this way. If you have a system in which issuers and acquirers have to agree what the interchange fee is to be, then in the absence of some way of dealing with an inability to agree, such as a default MIF or a regulatory cap on the level of interchange fees, there would be no alternative but for the terms of settlement between an issuer and an acquirer, including as to the interchange fee, to be bilaterally agreed. So unless you have a fallback, a default provision, or a regulatory cap, effectively says you can't go any higher, there would be no alternative but for the terms of settlement between an issuer and acquirer, including in relation to the interchange fee, to be bilaterally agreed. And in this context, the problem that arose because, as Milena Friend has said, of the existence of the honour roll card. And that is a rule, as Milena Friend has explained, which obliged acquirers to accept transactions on cards issued by each issuer. And the effect of this, of course, again as Milena Friend explained, is that acquirers effectively have no choice but to settle the payment with the issuer. That is to say, they have no choice but to reach an agreement, at least, that is, if there is no rule that applies in the absence of agreement. They cannot simply walk away, but they must agree something. And of course, because of the honour roll cards rule, the issuers have substantially more of the bargaining power. And it was a power which, absent any measure or default rule, the issuers could, and perhaps would, use to drive up interchange fees to excessive levels. Accordingly, my lords, if the card schemes did not adopt a prohibition on ex post pricing or settlement at par, zero move, and if there was nothing else that would prevent this happening, issuers would demand excessive and unreasonable fees, bilateral interchange fees, and that would likely cause the schemes to collapse. So that was the hold-up problem. We'll obviously need to come back to that. Just staying with paragraph 150 for a moment, the Court of Appeal judgment, your Lordship see that in the last sentence of paragraph 150, this court noted the CJEU's observation that it was common ground that MasterCard would have preferred to adopt the prohibition on ex post pricing than let its system collapse. So my Lord Justice Newey asks why it was that this was decided to be the correct counterfactual. Lord, at this stage, there were only two choices on offer. Either no MIFs, 0 MIFs, or letting the scheme collapse. If you couldn't have default, if you couldn't agree a positive MIF, the only possibilities were you have a scheme which, where you have the hold-up problem and the scheme collapses. That was the conclusion that the European courts came to. Or you agree no MIFs. And in that context, everyone accepted that MasterCard would prefer to take the no MIFs counterfactual and avoid the scheme collapsing. So, my lords, that is why the 0 MIF counterfactual was the right counterfactual in both the EU MasterCard case and indeed in the first wave of litigation in this jurisdiction. Indeed, as I've already noted, in the circumstances with which the courts were then concerned, and where the only alternatives were 0 MIFs or collapsing, a collapsing scheme, it is obvious which one would be chosen. And that, of course, is why we respectfully submit, and I'll come on to develop this tomorrow, the introduction of the IFR makes the world of difference, because the effect of that is to introduce the possibility of additional potential counterfactuals, not just 0 MIF or letting the scheme collapse. It allows for the possibility, provided you avoid collective agreements, measures in question, of a counterfactual where MIFs, well, they're not MIFs because it's not a collective agreement, where interchange fees are unilaterally and independently agreed between parties. That is, and they can't get to excessive levels. I'm going to take your lordships tomorrow to the regulation itself. The regulation sets the interchange fees at levels which it says it has determined are reasonable. And so once you have that boundary of a level of interchange fees which are reasonable, you can allow, without a concern about the hold-up problem, people to try and agree the fees, because although the issues still have some bargaining powers, they can't use it in a way which will go beyond a reasonable fee. And so that is what makes the difference. Before I leave the question of the relevant counterfactual, can I just very briefly, in what is not left of my time, and I apologize for running over time, just ask your lordships to look at page 1045, paragraph 181. Now, this does arise in a different context. It arises in a context where the tribunal in Sainsbury's MasterCard had found in the counterfactual that acquirers would have voluntarily paid positive bilateral interchange fees to prevent issuers from switching to the VISA scheme, which is what the tribunal had found. And on that, the Court of Appeal concluded that the tribunal was not entitled to reach that conclusion. But if your lordships look at paragraph 181, your lordships see this. We emphasize that we are not holding that no amount of evidence could have made it appropriate to find that even in a no default and a prohibition on pricing counterfactual, bilateral interchange fees would have been agreed. It might have been possible to show that the economic background to the MasterCard scheme in question was so different to that being considered by the Commission, the General Court and the CJEU, that a different outcome would have occurred in a similar counterfactual world. The evidence relied upon by the CAT, however, comes nowhere near to achieving this objective. And I'll show you that, just to remind the Court that the Court was not saying it doesn't really matter what the facts are, it doesn't really matter what the circumstances are. We're bound to find that this was the counterfactual. It was saying exactly the opposite of that. It was saying we accept that the facts and the circumstances can be different, and if that happens, we accept the possibility of a different counterfactual. Now, I apologise for running over time, my Lord.
No, it's very helpful, Mr. Rubin. It's probably better to go through the various references in one go,
Indeed.
rather than dividing them up. So we'll break now for today. 10:30 in the morning.
Compromise. The last live stream now.